class like this, and you really need this much time to do it. I mean, it's not, there's a lot of material, and the good part is that we'll be able to videotape this and put it on DVD so people can go back and look at the, you know, what was said, and refresh their memories, and we'll be able to put the DVD out to other people who couldn't be here. A lot of people across the country want this information. As you all know, I'm not a lawyer, thank goodness, and I don't purport to give legal information, but I've been in court many times, and my cohort over there, back there, has been in court with me on various occasions, and we know what's going on. So that's partly what I'm here to tell you about today, talk to you about what's going on. Let's start with a prayer. Almighty Father, bless this group and our families. Give us wisdom and give us courage. We're faced with an enemy of the Constitution that will destroy this country if allowed to proceed. We ask you, Father, Heavenly Father, that you not allow this to happen. We are patriots. We are Christians. We are other religions. Hopefully we all worship you, our Heavenly Father, the one true God. And we ask your blessings in the name of Jesus Christ, our Lord. Amen. Okay. This is, I'll tell you, it's wonderful to have groups like this. One of the best, it's probably one of the greatest blessings of my life to be able to meet people of your caliber. And when I say your caliber, I'm saying moral caliber. You stand up for what is right in the face of a lot of power, threats, in the face of all kinds of dangers to yourselves and your families. And yet you do it. We have over 4,000 members in the Lawman now. I just did a count the other day and it was over 4,000. Well, probably, I haven't answered my email in a day, it's probably up another 20. So we're gaining strength, and we have the law on our side, which is a shock to some officials that we know what the law is and that we can present it in court to the IRS and anybody. It's a shock to them to know that there's been fraud perpetrated on the American public ever since World War II. And that is all explained in the 27-page report. Started out as a 14-page report, went to 17 pages, 19 pages, 21 pages. And finally I decided to kind of finish it off, and it's 27 pages long. And that I offer that if anybody, any official can take that, tell me where we are incorrect on any of our conclusions in the report, or if they want to challenge any of the court rulings, they're welcome to do so. But none have done so yet. So it kind of says that by silence means consent, that they are simply acting now willfully and knowingly in violation of the supreme law of the land, the Supreme Court rulings of the United States. Not many people know that I originally started out as a relationship counselor. Some of my famous clients were Bonnie and Clyde, Bill and Hillary Clinton, Bill and Monica. And then Bill got into so many relationships that I got confused after a while. I finally figured I better move into research on the IRS laws because it was simpler than dealing with Bill and Hillary Clinton. So, anyway, our groups are made up of many different people from many different segments of society. The information we have is spreading. The reason it's spreading is because we're able to prove everything we say. The Achilles heel of the patriot movement in the past has been that so many groups have used so many arguments that are totally frivolous. Some were not frivolous. Larkin Rose's arguments are not frivolous, but he can't prove them in court. He has nobody to back him up on his arguments. He could have used the 21-page report in the Supreme Court cases, and then he could have relied on U.S. versus Bishop that says, if a person has relied on prior rulings of the Supreme Court, that they cannot be said to be willfully violating a law. That would be a very simple defense, and one I urge every one of you and the people that will be watching the video to rely on that. U.S. versus Bishop is a United States Supreme Court ruling. And I'll repeat it. It says that anybody who has relied on prior rulings of this court, meaning the Supreme Court, cannot be said to be willfully violating a law. And for those of you who are unfamiliar with criminal statutes, criminal law, in order to commit a crime, you have to willfully and knowingly commit the crime. If you gentlemen should accidentally stumble into the ladies' washroom someday, that is not a crime. If you didn't know it was a ladies' washroom and you didn't willfully do it. So you have to understand the nature of willfulness and knowing for criminal law. The argument a lot of patriots have offered in court and gotten shot down on is the issue of willful. That the lawyers seem to only want to offer one argument in defense of their clients, and that is the willful thing. Even though the lawyer may know about these Supreme Court case rulings, I supplied a lawyer with these court rulings, probably 2 months ago. And he's not going to use them in the defense of his client. Well, same thing is going to happen to his client that happened to Larkin Rose and Dick Simcannon. Even though Dick Simcannon and Larkin Rose used the 861 argument, that argument cannot be backed up. I mean, it's basically saying that this is my opinion of what the law says. And the judge will say to the jury before they go to deliberate, and we all know that we have a duty to pay our taxes. That kind of puts the jury into a bind. I've seen it before in federal court where the judge tells the jury that. The judge won't say, nor will the IRS say, that we all know we have a duty to pay the income tax. They avoid using that. Look at their literature. They avoid saying everyone is obliged to pay, is liable to pay the income tax. They say, we all must pay our taxes. Well, we pay a lot of taxes. We pay taxes every time we move, every time we breathe, practically. So, even when we have our children, when we retire, we pay taxes, taxes, taxes. So, the income tax is a specific type of tax, and it's authorized as a direct or an indirect tax in the United States Constitution. And that's where we really follow them up, is because we know the definitions of direct tax, and we know what the requirement of apportionment is, because the Supreme Court has told us. We even have in the regulations, recently I added regulations that say that wages are a direct tax. So if the regulation in the United States Code of Federal Regulations says that wages are a direct tax, then they must be apportioned. But the corporate income tax is an indirect tax, and because it's not a tax on the income of the corporation, it is a tax on the privilege of incorporating. And it's only measured by the size of the income of the corporation. So once you can understand that and look over all those court rulings in the 27-page report, at the bottom of the report are about 8 conclusions. And if the government wants to disagree with any of those conclusions, I welcome them to disagree. The problem for the government is that they're silent on that. So basically, we have a terrific foundation in law for our position. It's never been refuted. We also have 2 other separate and independent arguments other than the Supreme Court rulings. The other one is the Statutes and Regulations requirement, and that's U.S. versus Mirsky and California Bankers and Wait, and then a couple of others that I have in my case law. But those rulings say that in order for a law to apply to the general public, there has to be not only a statute or a code section, but there also has to be an implementing regulation promulgated by the Secretary of the Treasury. If there is no implementing regulation, the statute is just benign. If you look at statute 6702, for instance, 6702, if you look in the table of parallel authorities, there is 6702 has no implementing regulation. And as soon as we start bringing that up in our paperwork to the IRS, lo and behold, the IRS stopped imposing penalties under 6702. Then they start grabbing for straws in 6651. Well, 6651 only has regulations in Title 27 of the Code of Federal Regulations, and that is alcohol, tobacco, and firearms. So there's massive fraud going on here. It's been going on since the Second World War. And now we can prove it, and now we're confronting the government with it. And we're not going to allow the government to continue this fraud. And what's amazing is when you tell people the truth, and then they can recognize it, they can see it in the Supreme Court rulings, it jars them. It really starts waking people up. I know a lot of people right now in the Lawman who started out with all the goofy arguments and everything, and now they understand that we have a legal basis. We're not doing frivolous arguments anymore. The Lawmen never did do frivolous arguments, but so many of the other groups have. That I would, you know, even We the People at one point had on their website, this was several years back, It basically must have been written by a lawyer, and I don't know who it was written by. But it says the Supreme Court itself was confused on the issue of income taxes. That's hogwash. The Supreme Court knew exactly what it was saying in every one of those cases. And we destroy our argument if we're saying the Supreme Court is a bunch of idiots. I've had so many discussions with people, including my wife, where she'll say, well, this person or that person started a church for the purpose of evading taxes. And I say, no. How do you know that? How do you know that what that person's intention was? I said, whether you think that may be the case, doesn't make it a fact. And this is where we're getting into where what we do in court is we deal with facts. We don't deal in suppositions that have no foundation or basis in fact or law. We deal with what the law says, and if the Supreme Court makes a ruling, even if it's an old case, as long as it's still a good case, that is part of our common law. A lot of the patriot groups have argued that common law doesn't exist, that we only have statutory law. Well, that's a myth, and it's very harmful to the patriot movement. Sometimes I wonder if some of these myths got started by people who were disinformation specialists and got this kind of stuff going on in the patriot movement, and then it spread and spread, and everybody was using these goofy things. We have a rule of thumb in the Lawman organization. If you can't use the argument in court, don't bother with it. It's a waste of our time. So let's not waste our time or your fellow members' time. Don't waste. Don't spend your time and efforts talking about needless things that don't apply. I can't tell you how much time has been wasted by the patriots. Instead of learning the information I'm going to teach you on this subject of going to the court, they talked about the gold fringe on the flag, the UCC argument, which is nonsense. I mean, it's not complete, utter nonsense, but it's frivolous as far as the application of taxes. They talk about just numerous things. They'll say the 14th Amendment makes you a slave. If you read the Supreme Court rulings on this 14th Amendment, can you honestly say that the 14th Amendment makes us a slave? That's baloney. It's absolute baloney. And I'm very confident in what I'm saying here because I've looked at these arguments over from every which way point of view, and I know we're right. I know we're on the right track. And one of the reasons I know we're on the right track is because the government always backs up and they clam up. And we all know under the Supreme Court rulings of U.S. versus Tweel, Carmen versus Cohen, and a number of other cases, we all know that when the government or a government agent leaves a question unanswered, grand theft. We're getting to the end of the trail here, and or uses false and misleading statements that can only be construed as fraud. And when you're talking about fraud of millions and billions of dollars, that is massive fraud. That's why That's why this is so good. And I can tell you so many of our groups are excited about what's happening here. Our Florida group, it grew like a weed. I was down there in February, I believe, and the Florida group, I was contacted originally by a couple of the people down there, and they said, well, we have a lot of people down here in the tax movement. And they says, well, you know what, if you want us to get the information and stuff, you know, we could probably get a whole bunch of members. Well, since that point, we've got about 7 groups in Florida. The Tampa group is over 60 people. The St. Peter's group is about 15 people. The Orlando group is about 50 people. The West Palm Beach group is about 40 people. And it's growing every day. I mean, that's just Florida. And one of the nice things about the Florida group, they jumped right on what I was trying to get the groups to do. They didn't have to be dragged or cajoled into forming their public interest group. They just went out and did it. Partly it's because they knew that what I was telling them was the truth. And that's what we have to convince our fellow citizens of, that what we are saying is the truth. And we can back up everything we say. Once you can do that, then you can convince people. If you start introducing frivolous arguments or arguments that don't hold a lot of weight, I mean, they may not be incorrect arguments. Like there's form-driven arguments about, well, this form doesn't have a OMB number on it. Now, that's a legitimate argument. However, I can tell you the way the statute is written in the code book, you're not going to be able to argue it in court. The judge is going to just rule against you. So the IMF is another argument that won't really get you any place. You can, and they're absolutely right. I'm convinced that all these people are being listed in the IRS records as manufacturers of truck parts in Guam, in Puerto Rico. I've seen some really bizarre things when they decode the IMF, the individual master file, for those who aren't familiar with it. The IRS keeps an individual master file on every individual, and they will list you as being something. So they have to fool their computers. They have to fool them by saying you live in Guam or Puerto Rico. So we have to be aware of this stuff. However, the problem with arguing that is going to be this. If the IRS can change those numbers on your master file in an instant, all they need to do is have a clerk type in some new numbers on that IMF file. And then how do you go to court and argue that? I mean, it's possible, but they're going to say, well, we just had our clerk just made a mistake. Okay? So I want you to be aware of the fraud and how we can fight this, but also what arguments we don't want to use to fight this. You don't want to use weak arguments, nor do you want to feed the other side partial arguments that they'll be able to use against you. One more thing I want to mention is some of the groups. There's a guy in Ohio that started passing out this information and saying that income taxes are imposed by a privilege that we gain by using the U.S. Postal Service and by using the zip code. you can laugh and chuckle at that, and I do. I pull my hair out on it. It absolutely floors me that anybody would buy nonsense like that. But anyway, a lot of people have. And so what they do is they put brackets around the zip code. Well, if you ask any postal clerk, brackets around the zip code means that it's out of the country. You know, it's a foreign mailing from someplace to this country, from this country to the foreign country or whatever. Anyway, that's what they do. In fact, I just visited a lady in jail this last week. Very nice lady, intelligent, but she's in a group of people who use those very same arguments. And the fact that she's in jail means that she didn't have confidence enough to argue it in court, and she kind of took off. So now they've got her in jail because she's a flight risk. See, you end up, when you go off the course, when you divert from your objective, then they say, you don't feel comfortable with the arguments. When you don't feel comfortable with the arguments, you're not going to want to go into court and use them. Oh, I can't tell you how many people I know are in jail today because they've used these goofy arguments. And then the judge wants to put everybody, all of us, in jail. I mean, that's a fact. They're not going to be impartial toward the tax movement people. And we are not tax protesters. Don't ever let them tell you that. They are the tax protesters if they won't accept the Supreme Court rulings on the 16th Amendment and on the Pollock case and the Butchers Union case and all the cases that followed in the wake of the 16th Amendment. They're the tax protesters, the judge, the prosecuting attorney, the IRS agents. They're the tax protesters, not us. That's why I'm very, very confident about this. Now, I went up to the IRS with a couple of witnesses in February?
Yeah, February.
Okay. And they asked me, oh, did you have any income? I said, no. They said, well, what's your definition of income? I said, I don't have my own definition of income. I use the Supreme Court definition of income. They said, well, what's that? I said, well, just a minute, I'll get it for you. And I had my 21-page report at the time, and I looked through it, and I found a nice definition. Then I read it to him. And he just dropped the matter right there. That was the last he said on it. See, they know. And we don't have to go in there like a bunch of little sheep to be sheared. Which brings me to our whole class, which is going to be how to go into court, how to do your preliminary stuff. And one of the things I want to alert you to right now, and all the people that will be watching this video, never go into court empty-handed. If you do that, what's going to happen, you go in there and you sit down and you say, well, what's this guy going to say? What's the lawyer on the other side going to say? What's the judge going to say? I'm scared. I don't know, maybe I won't be able to answer these guys. You always go in with your case prepared, in writing. You never go in empty-handed. And there, you know that, and you have a copy for the court, a copy for the plaintiff, if they're the plaintiff or if they're the defendant. It doesn't matter if you're the plaintiff or the defendant. You need to have your stuff all the time when you go into court. You need to have copies to present to the court, enter into the record as evidence. Now, the Supreme Court rulings are in the public record. And those rulings must be adhered to by the judge. That's precedence law. And it's stated in the judge's oath of office. I have numerous things that I've prepared lately, and let me, I think I could probably pass out a couple of things. Okay, I made some copies of this, how to file a lawsuit for pro se plaintiffs. Pro se means in Latin for myself. Okay, I'm acting for myself. Pro se. And in Haynes versus Kerner and CIA versus Plasky, they refer to pro se plaintiffs. So now my question would be, why would anybody want to use sui juris or pro per or any of the other phrases when the United States Supreme Court refers to us as pro se plaintiffs? And using that term, they give us a lot of leeway. They say we cannot be held to the same standards as trained attorneys can be held to. Here's one. I've got 5 copies for the class, and you guys can you can make copies, you can pass them out to the other people. They will? Okay, please, please. But you don't have to do it now, you can do it at lunch if you want. We don't need to, we're not going to go through this whole thing, but the reason I copied this out was because it was probably one of the best presentations that I've seen in the U.S. District Court. I was using the District Court in Western Michigan's write-up, but it doesn't even come close to comparing with this write-up. The write-up is very good. However, they still don't tell you everything. So I just want you to be aware of that. You have to know the other things, how to, you have to know how to argue. You have to know what the judge's code of conduct is. I would suggest that every time you go into a court, you have the judge's code of conduct printed out on a little, maybe 5 sheets. And so that you are familiar with it. Once, if the judge steps out of his code of conduct, you read from the code of conduct to the judge. You read it to him. So, Your Honor, the code of conduct says that you must avoid even the appearance of partiality or favoritism or cronyism. Yes, sir.
And 2A also says that they will honor decisional law, which are Supreme Court rulings.
Absolutely. See, there you got the judge. This is why I recommend going into federal court rather than into state court, because there's a lot of advantages to going into federal court. Most of your pleadings will be on paper, up until you have a conference with the opposition. Most of your pleadings is going to be on paper. And your big hurdle is to get over summary judgment. But we'll talk about that, and I will write that up here on the chart. So I've laid the groundwork. You guys now know some things that you have to be aware of when you go to court. Now I hope everybody's aware of the difference between federal and state government. Believe me, a lot of our people don't know the difference. And the Supreme Court does recognize the difference and distinction between state and federal government. And they make rulings all the time. One ruling was insurance company, and it was about 1960. Anyway, it said that, and it was a case about filing notice of liens in Michigan. And the Supreme Court maintained the distinction between federal and state by making a ruling. The federal seemed to say one thing and the state said another thing. So he said, the court ruled that since the state had not authorized a filing place in the counties, that the federal government could not file liens in the counties, in the state offices. It was an insurance company case, and I've got it in my files, about 1960. Now, since that time, the state of Michigan says, well, we've deleted that statute, and so that statute doesn't apply anymore. But I think you can still use that because the same standards apply. Anyway, that was it was an insurance case anyway. So you have to know the difference between federal and state government. Then you have to know the difference between criminal and civil law. So if you don't have a good grasp of these distinctions, you'll wander back between federal and state in your arguments. You wander between civil and criminal in your arguments. There's another thing that people commonly do. I mean, I've seen this so often in our groups. I'll be talking about civil lawsuit, or not civil. I'll be talking about a civil lawsuit filing. And when you file a lawsuit, you are the plaintiff. You have a defendant over here. That could be the county, it could be the IRS agent. And people, I will be talking about filing, how to do a thing, and then somebody will pop up and say, well, how can I get this case dismissed? And they'll say, well, we could do this to get the case dismissed. Well, if you're the plaintiff, do you want to get the case dismissed? No. And people don't, they don't connect. They don't think in terms of being a defendant or being a plaintiff. Up until now, all the patriot groups have always thought in terms of being a defendant. That's it. And so you have to make people aware. You have to make these distinctions between federal, state, criminal, civil law, and then if you're the plaintiff or the defendant. If you're the defendant, you're going to try, your objective is to get the case dismissed. If you're a plaintiff, your objective is to keep that case going. We have some really, really powerful arguments, and the judges are having a terrible time with them now. We could not be doing these arguments if we had ever relied on the goofy arguments. Believe me, we couldn't do it. Because you could have 10 good arguments and you just put one goofy argument in that mix, and the judge and the lawyers will say, you're not competent to represent yourself in court, I'm dismissing your case. Don't do that. If you're a plaintiff in a civil lawsuit, there are certain things you have to do. You have to write up a complaint. The complaint might run to, a lot of ours run to 50, 60 pages. That's not too bad for a complaint. But I would urge you to stick with the essentials of the complaint. Don't get into the frivolous arguments, because what's going to happen if you don't pinpoint your arguments like a laser, the judge will say, well, this complaint is frivolous. And then you've got to defend all these other things. And I always tell people, when you write up a lawsuit, you want to make it as simple as possible. Make it as simple as possible. For instance, supposing you've got 10 defendants. Supposing you went all the way through, and it took you 3 years, you went through court, and you won the case. The judge could dismiss it. You know why? If you had failed to allocate damages to all those 10 defendants and present those damages to the jury for, verification that those damages are reasonable, he could dismiss it. That's one of the case rulings. It says if a plaintiff doesn't allocate damages to the various defendants, that could be dismissed on that basis. So you want to make it, if possible, one defendant, maybe two, if you want to link them together for a particular purpose. There's another thing you really have to consider here. I hope you can hear me. Civil cases, the judge can grant a motion for dismissal. Even if you're right and everything, he'll go ahead, he'll grant it, but he'll break the rules. He'll break court rules, he'll break precedence law, he'll break all kinds of things in this. So you have to fight that through every time. But there's the other angle, which we started using a little over a year ago now. That's the criminal complaint. Judge can't dismiss a criminal complaint unless he can show that it's frivolous. If he can show that you cannot prove your allegations, then he could dismiss the criminal complaint. In our our criminal complaint against the 12 operations managers, we have 14 counts against them. And we could probably add more counts. But we can prove all of those 14 counts. And we have 1,000 witnesses against these agents, these operations managers. So we have 1,000 complainants and 1,000 witnesses in that criminal complaint. What's the judge going to do? Say, oh, all your arguments are frivolous. No, what they did was they went silent on it. When we went to TIGTA in the beginning of our criminal, as we progressed through our criminal thing, we went to TIGTA. Well, we first went to some judges. And one judge here in Michigan referred me to a prosecuting attorney in Detroit. So I got a letter from one of his assistants or aides. I don't remember what the letter said, but anyway, I responded and I said, I would like to meet with the prosecuting attorney because I wish to present some evidence of the criminal nature of these IRS agents. He wouldn't answer that letter. That's fraud. So that was a prosecuting attorney. I want to refresh your memory too. In 1992, practically the day after Bill Clinton came into office, he did something that nobody's done, no president's ever done. He fired all the criminal prosecutors. He fired them. There was like, 300 or 350 of them. Fired them all. He appointed his own people in there. People that would be lackeys. People that would only prosecute those cases that he wanted prosecuted. It's criminal what's going on here. Now, the Patriots have been complaining for years and years and years. Oh, the country's going to hell. We're losing our country. We're losing our Constitution. That's true. The real question is, what are we going to do about it? If we sit there and just whine and complain, it ain't going to do any good. You could get out there with signs with 100,000 people. It ain't going to do any good. Because the government officials do not want to uphold the Constitution of the United States and the laws of the United States. They simply don't want to do it because they're caught in this system. It's like James Trafficant came out with some very good legislation. He was a good man. He's a Democrat, by the way. But he was independent-minded, and he came out with some good stuff. They framed him. I have a copy of a letter he sent out of prison that the government produced witnesses that lied in his trial. So they threaten and intimidate the congressman. We're not going to get the answer to this problem by going to Congress and begging them. We have to hold them to their oath of office. That's the only way we're going to do it, in my viewpoint. And holding them to their oath of office is what we're doing now. We've started in that process. I'm going to write up a new one that everybody will be able to file with their congressman. They can file it with 10 congressmen, 10 senators, I don't care. We need to smother Congress with their wrongdoing. And if they're going to repudiate their oath of office by not upholding the laws of the United States and not upholding the Constitution and acceding to fraud, get out of your office. Get out. You've already vacated it by your actions. You repudiated your oath of office. You repudiated your duty to uphold the law and the Constitution. As such, you no longer are entitled to sit as a congressman. The same way with the judges. Who are we? We're the citizens. We're the citizens of this country. And there's a lot of people that are awful mad at what's going on in this country. They are mad. Bill and I go to church and we talk to people about this stuff, and you can tell they're mad. We have a friend from Hong Kong, and he said that the people that come here from Hong Kong say, we thought this was a free country. We find that there's more regulations and taxes on American people than there are on the people in China. And I had that same comment from some people who moved to Hawaii. They thought, well, America's a free country. And then they found out, well, why do they have all these taxes on everything? Why do they have all these regulations controlling everybody's life? There's one answer to that. Because the Congress, the officialdom, have been misapplying the laws as they are written and ignoring the Constitution and taking actions under color of law. Color of law means that it appears as though they're acting under law. But really, in reality, there is no law supporting what they're doing. We see that in our local officials in the ordinances that the local townships pass. I don't have a problem with that at all. Hey, let them take me to court. Because, first of all, the township ordinances in Michigan is chapter 41, section 181 to 185, and it says, where they say that there has to be two things for an ordinance to be valid. It has to refer to the statute passed by the state legislature, and secondly, it has to state on the ordinance the purpose of the public act that was passed by the state legislature. So now the purpose, not the purpose that the township people say is the purpose of the law, but what the state legislature says the purpose of the act is. And they don't have that on either one of those requirements. They do not have on the ordinances they pass. And I'll tell you, when I brought that up at my township, they went into a panic, a literal panic. The lawyer could not do anything but tell one lie after another. And what's so unusual about a lawyer lying? We all know that. Anyway, now we can prove it. And we have a gentleman here that got a postcard. We have two gentlemen that got a postcard that there's an arrest warrant out for them.
What?
Postcard? Yeah, it's postcard, unsigned postcard. That's what they're doing in Michigan. What they want you to do is be afraid, and then go in and pay whatever fine they tell you you owe. They want you to be afraid. They want the troops of people that come into the Calhoun County courthouse and pay 150, 200, 300 bucks fines. Just keep shelling out the money. Pay your money and get the hell out. That's really what they're telling the citizens. And they're doing it under color of law. So anyway, when we did these, when we addressed, we wanted to see the actual arrest warrant, not a postcard. We wanted to see and with an arrest warrant, what has to go with an arrest warrant? Can somebody other than those two gentlemen tell me? Yes, Bill.
Complaint?
Complaint, yes. What else?
Judge's signature.
It has to be a judge's signature.
Does there have to be an affidavit as well?
Yes, there has to be an oath statement by somebody who is your accuser. Yes, that would be the complaint, but a complaint could allege certain things, but there has to be an oath statement with the complaint. And that's in the Constitution. Okay, what else has got to be on the complaint?
Seal. The seal?
No?
Signature.
Certification.
Witness. It's got to be delivered. Properly.
Yeah, served, yeah, okay, but what else? What's the constitutional requirement? Probable cause. If everything they do, they have to have probable cause for, practically. They can't just come to your house and say, we want to come in and search your house. They can't just go up to Joe Blow's house down the road and say, we want to search your house because we don't like the way you look. They have to have probable cause accompanied by an oath statement. Our problem is I think it stems from our public pool system. The public pool system has not done its job. We have kids graduating from the public pools with not knowing how to read and write, without knowing how to do arithmetic, simple basic arithmetic. They can't make change for $1. I'm not exaggerating. And yet, they'll give them courses on sex education, which leads the kids into all kinds of trouble. They'll do all kinds of silly stuff. Actually, the school system ought to be sued for damages to our children. And if anybody ever learns how to do the lawsuits properly, you could probably sue your school system for the damages to your children. But I would, if I were a parent and if I had a kid in school today and I knew, and I wasn't involved in all this other stuff, and I knew they weren't teaching my kid, I would sit my kid down one day. I would say, okay, I want you to make change for $1. I want you to add 56 and 93. I want you to subtract 25 from 50. I want you to write a decent sentence with correct punctuations. I want you to read a book. And I want you to tell me what the book says. And if the kid couldn't do that, and your child couldn't do that, and they were in high school,
I would immediately file a lawsuit on the grade school and the high school for admitting them. Because that's damages. That is severe damages, and that's why people are getting punished today, because they're uneducated and they don't even know it. And one of the big things that they pushed in the late 70s was this feel good about yourself. You know, the whole important business in the public school system was to make the student feel good about himself. Well, if you're a competent bank robber, I guess you can feel good about yourself, right? There's so much nonsense they have promoted in the school system, and so much lack of what knowledge that they haven't passed on, that we're in the situation we are today. So now we've got to start the education process among our groups and other groups. We need to get people to understand the law, how to read and write. If you don't know how to read and write, basically this is your chance. You've got the internet, you have the spell checker, you have things that check your grammar and your punctuations, capitalization. There are things that help you. And now this is the time to do it, even if you're 50 years old. Believe me, when I was 50 years old, I didn't know any of this stuff. None. Zero. I was as dumb as the most recent high school graduate. Bob Schultz said that he didn't even know that there were state constitutions when he was 50 years old. So what we need to do is educate ourselves and make ourselves so valuable to everybody around us that everybody wants to associate with us. That's important. It's just like when you go to an employer and you make yourself so valuable to your employer that he can't afford to fire you or lose you. And that isn't usually the case, but that is the case with some people because they are so good at their job. Well, okay, remember to keep the distinctions between these things. And what your goal is, if you're the plaintiff, your goals are going to be different than if you're the defendant. So remember that, whether you're a plaintiff or a defendant. If we don't stop what's going on now, everybody in this country is going to be a defendant. Pretty much that's the way it is now, because if you look at you go down to your local courthouses through the week, Monday through Friday, they have streams of people going in there to pay fines. So those are all the defendants. But I'll tell you what, the government's doing us a big favor, because they are angering the people to such an extent that the people, when they see a way to correct the abuses, they grab onto it. So we're getting a lot of allies. We're getting in our Lawman organization probably usually 10, 20 people every day. We've got over 4,000. And we still got people in the Lawmen that want to use the goofy arguments, that want to waste time on arguments you can't use in court. But we're gradually trying to get people to understand you want to focus in on what you want to accomplish. We want to accomplish the elimination of the income tax or the proper application of the income tax. I really don't care if the corporation pays the income tax. But I do care when they're applying a direct tax against a citizen, because that has always been a natural rate given to everybody. It's in the natural law. How do you determine what is natural law? Well, like the founders of the country understood natural law. They wrote it into the Constitution. They said that no direct tax could ever be imposed on people of the states unless they're apportioned. They never envisioned that we would have taxes on every excise taxes all over the place. They never envisioned that the government would impose a direct tax on a person's wages or salaries. And that's why they wrote those two provisions in Article 1, Section 9.
Section 2 and Section 9.
Section 2 and Section 9. No direct tax shall be applied without apportionment. So, if the internet had not come along in the late 90s with all the research capabilities, we may never have been able to expose the fraud that's been perpetrated on us. So can we say that the lawyers are competent? Have they done their job?
Well, it depends on what their goals are. If we, I think according
If they want to rape, pillage, and plunder, they were very competent at
they're
that.
doing a good job.
Yeah. But if they were trying to uphold the laws and see the proper application of laws, I think the lawyers stink. And the average person out there knows it. I have a lady in our township who had two wild pet ducks that made their home in her backyard, and her backyard fronted on a river. So they would go out and swim in the river, roam around her backyard, and then she would have shelter and food for them during the winter time. Well, one day she gets a knock on the door. Code compliance officer. Code compliance officer says, "You're keeping poultry here. That's against the ordinance." The woman spent $900 on a lawyer to defend that. So she won the case, but she lost $900 and she had all kinds of grief for months over that. And I told our township, I says, "That's outrageous that you would do that to this woman." I says, "It's outrageous that you would misapply laws like that." Their excuse is, "Well, we didn't know. We just were doing what we were told to do." Okay, so we need to be able to go to court without a lawyer. If you go to court with a lawyer, the lawyers are very intimidated by the judges. You got to know that up front. They're very intimidated by the judges. The judges will get people sanctioned, lawyers sanctioned. They can't sanction you. The judge does not have the same intimidation tactics to use on you that he could use on a lawyer that represented you. So just remember that. And you have certain advantages in court. As a pro se, just a second, we have Haynes versus Kerner and CIA versus Plasky. Not only says that we cannot be held to the same standards as a trained attorney, but it also says that if our complaint or our filings are incorrect, the judge has to instruct us how to correct them and give us the opportunity to file the correct complaint. Also, if you go into federal court, you've got a one-time charge, which is when you file your complaint, and it used to be $150, now it's $250. But they don't charge you for motions. So in state courts, they charge you like $50 every time you want to make a motion. So if you make 3 motions, they want to charge you $150. So use the best avenues that you can use. If you have a constitutional issue, which is like, for instance, a deprivation of your constitutional rights, and probably all of us in this room fall in that category, that should be brought to a federal court, not a state court. They'll bump you out of the state court, and then you wasted your time, and then you got more expenses and aggravation, and you complicated your case immensely. Go to federal court. Go to the proper court in the first place. Make your allegations specific. Yeah. When you go to court, what are the two main things you have to argue about in court? Can anybody give me a clue?
Subject matter, jurisdiction.
No, you are conferring subject matter jurisdiction by providing these two things. What two things are they?
Pleading sufficient to establish a controversy.
Yes, but what's in the pleadings that establish the controversy? What is in those pleadings?
Your statements.
Those are allegations, okay? Okay.
Remedy that would need to be granted.
No. 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 What are
Statement
the...
fact?
What?
Statement fact?
Well, you're close. Steve, you almost, you touched on one of them. Okay, what would that be? Facts. Okay, so you got two things that really have to be argued in court. Facts. What else? In other words, you're just going to go in with a bunch of facts?
What are your damages, yeah.
Well, yeah, but to get to the damages, you have to do these two things.
You have to swear the facts.
Is it
Yeah.
You have to prove it.
The law?
The law. Steve got it. You get an A, Steve. Okay, the law. The law and the facts. And the reason I want to emphasize that right now is because in 2002, Clarence Thomas, Chief Justice, wrote an opinion for the entire court, and it was in the Federal Maritime Port Authority versus South Carolina, 2002. And Judge Thomas said that the court, meaning the judge, the court must provide all the findings and conclusions. Now, both of those are important. So, like for instance, supposing a judge dismissed your case, you would make a motion for the findings and conclusions of the court. And what are these findings and conclusions supposed to address? Law and the facts. Very good. One more thing. Any discretionary matters that the court may have before it.
In other words, how you arrived at his ruling.
Well, if there were extraneous discretionary matters outside of the law and the facts, you're not going to run into that much discretion. You're basically dealing with the law and the facts. Now, supposing you provided the law and you provided a violation, say, of your constitutional rights, and you can prove it through the court cases. So you provided the precedence law, okay? So we're not only talking about the law as written in the statutes or written in the code sections, but we're also talking about precedence law here. Oh, excuse me. Precedence, then you have codes, and you have statutes. And what else do you have? And regulations, right. And what else do you have? What else do you have?
Supreme Court cases, Supreme Court rules.
Well, I've got that in precedence.
sorry.
Precedence law.
Limitations.
Pardon?
Limitations.
Okay. There might be statutes of limitations, but those would come under statutes. Okay, statute of limitations would, they might be cited in the code sections, or they might be in regulations. But there's one other big thing, that is the law. It's called the fundamental law. What is the pardon? The Constitution. Right. So let's add the Constitution in there. So we're getting it real crowded here. This is what you're going to rely on when you argue the law. Now, a lot of judges have misapplied some of the court rulings and say you can't argue the law. But yes, you can. You can rely on the law. You're not arguing the law. You're presenting the law as provided by the Supreme Court in our precedence law. It's the same way as supposing you were to say, here's a code section, Your Honor, and you provided that in your pleadings prior to that, and you say, this code section says ... Well, it's the same thing in providing the precedence law. The Supreme Court, Your Honor, says ... And you, Your Honor, are required by the Supreme Court itself in the Judge's Code of Conduct to follow precedence law, and we have an adversary system of law. Look in that Judge Thomas decision. He states it again that we have an adversarial system of law. That means you're on one side of the fence, the other guy's on the other side of the fence, and you have to bring your arguments to the court. The judge makes his decision based on the arguments the two of you bring to court. The judge is not supposed to be introducing all kinds of statutes or Supreme Court rulings, unless perhaps if it's a Supreme Court ruling that says, well, this thing is entirely frivolous, the courts don't have to consider this matter. Then the judge can present that and say, well, look, you've presented an entirely frivolous matter here. The courts don't have to consider this matter. I'm dismissing this case. So when you're arguing the law, you're not going to argue the law, you're going to present the law. Don't let the judge trap you into saying you're arguing the law. You're not arguing against the law, you're simply presenting it. And the Supreme Court rulings are made so that the average person can understand the Supreme Court rulings. That might be debatable, however, that's what the purpose of the Supreme Court rulings are, is to clarify the law. Okay? So if they're trying to clarify the law, who are they trying to clarify it for? We the people, I believe. If they're only trying to clarify it so that judges and lawyers can understand it, how am I going to obey laws that I can't understand? So you ask the judge, well, Your Honor, this is the Supreme Court rulings that I'm supplying here. And my understanding is that everybody's supposed to be able to understand the law as it's written. And these are clarifications of the law. All of our 27-page report rulings are clarifications on the 16th Amendment, direct taxes, excise taxes, the taxing power of the federal government. Now, are you telling me, Your Honor, that I can't rely on the law? In other words, I'm supposed to come in here like a dummy and drool. I refuse to do that, Your Honor. And you're denying me my my due process of law if you tell me I cannot rely on the law.
And violating your code of conduct.
And violating your code of conduct.
And
That's
two ways.
That's right. You're telling me, Your Honor, that this man here can rely on the law, but I can't. That's a violation of my due process. So you have to know how to argue these things. So the good thing is we're going to get this on DVD, and people can go over this stuff and remember how to argue. Now we are going to spend probably, I would say almost a whole day on doing arguments in court, oral arguments, doing your pleadings. Oh, Kathleen, did you have a question? I'm sorry.
I did. You said the judge can get a lawyer sanctioned. What does that mean?
Means that he can say, he could go up to even barring a lawyer, or having it suspended from the bar for a period of time. And they do that with lawyers. Or disbarred even, yeah.
Just
But,
by their say-so.
yes, because what the other judges will back the judge up.
And not only that, that lawyer doesn't want to come back into that judge's courtroom ever again.
That's right. Because if he's a plaintiff's lawyer ordinarily, he's got to win his cases. Now, the one protection for the lawyer is if the lawyer will learn this stuff, and he will do void judgments on the judge when the judge steps out of line. He will remind the judge of his code of conduct, but it's a very rare and exceptional lawyer that will do that. We have several lawyers in the Lawman, one in Kansas, one in Massachusetts, one down in Alabama, and I think that these fellows are very honest men. I know that there are honest lawyers, but they're trapped in that system. The only way we can break that system up is if we go into court and break it up. We can do it as pro se plaintiffs. We have the law to rely on, and we have court rules that we rely on. Tomorrow we're going to spend our time on court rules. We could spend all day on court rules, believe me. And you will love court rules. Because you know what? The court rules are there for our due process, and they are there to obtain justice, to see that justice is done in the courts. And that's why the judges have to violate court rules in order to accomplish what they've been accomplishing. The patriots have not known this stuff. Most lawyers, I've had calls from lawyers asking me for my advice. And most lawyers don't know a lot of this stuff. I mean, I don't know. It depends on the lawyer. You know, some lawyers are very incompetent. I've met a few that are extremely incompetent. I mean, they're like high school kids. I've met one of the sharpest lawyers I ever ran into was what I call it, my evil genius. He was the first lawyer I ever ran up against. I mean, that guy threw everything in the kitchen sink at me, and I didn't know what to do. I did the best I could, but that was before I learned all this stuff. For instance, supposing a lawyer makes an allegation on paper or in court. He makes an allegation. He says, the law says this, Your Honor. Do you know how to object to that? No. No, you object. I mean, if the law actually doesn't say that. Because, for instance, this lawyer used that. Remember that insurance company I told you about? The lawyer said, made a statement about that case, saying that it authorized something. And he had it in his pleadings. And when I looked it up, I found out that the lawyer was perpetrating fraud. He actually used a court case, and he's supposed to be competent, right? Isn't he? Yeah. So he's assumed to be competent, and he's using case law in a deliberate, planned effort to perpetrate false notions on the court. False and misleading statements. Bill knows of one particular lawyer. Let's name that lawyer right now because I love the man so much. He's given us so much to work with.
Which case? We've got 2 cases.
Okay. McKee.
Oh, McKee, the McKee case. The name of the lawyer we're talking about?
No, the name of the judge.
Oh, Judge David W. McKee.
Yeah, Judge David W. McKee was just appointed by President Bush to the Sixth Circuit Court of Appeals because McKee is a constitutional government, as George Bush is so fond of saying over and over and over to all the dumb Republicans out there. Okay, I'm not against Republicans, but I'm telling you, the Republicans, the Democrats, and our citizenry, they are so dumbed down, they can't tell truth from lies anymore. And what David W. McKee did was outrageous, absolutely outrageous. Bill has absolute proof that the IRS perpetrated fraud. Bill presented that fraud to the court. Judge threw it out. In other words, the judge acceded to fraud.
Now that was the Robert Holmes Bell case.
Oh, that was?
Yes.
Okay. Well, McKee did other things.
Yes, McKee did the same thing and presented irrefutable evidence
That's
that
right.
there was a false report given by a police officer
That-
had the evidence that he couldn't refute through an affidavit that was given by a witness that was supposedly quoted by that police officer that rebutted the statement that the police officer made. In other words, that witness said the police officer lied.
That's right.
And it gave that statement to the
She
judge.
signed that under penalty of perjury that the officer lied.
And, yeah, exactly.
And McKee thinks it's all right for a police officer to lie and produce a case on the basis of lies. It's the same thing I did when I went up to Grand Rapids for the hearing for our lawsuit against the IRS. And Judge Ellen Carmody was having the hearing. And I told Judge Carmody, but Your Honor, you did make a decision. And your decision was based on nothing but lies. Misstatements, misleading statements, and false statements. The whole document, and I pointed at the DOJ attorney, I said the whole document that she submitted was all false and misleading statements. And you made your judgment based on those false and misleading statements. And Judge Carmody looked at her, looked back at me, and she said, well, I'm going to end this hearing. I'm granting the hearing in part and denying it in part. Then she paused a minute. She says, I'm granting this hearing in part and denying it in part. And then she ran out of the room. I mean, this woman is one of the worst examples of a judge that you could imagine. She's only a magistrate. So in other words, magistrate judge is like a judge in training. Apprenticeship. Yeah, it's like an apprenticeship. Yeah, it is. So anyway, magistrate judges don't have the power that a regular judge has. But guess what happened after that point? After that point, Judge Enslin, who is a full judge in Kalamazoo, acceded to the fraud too, because he dismissed the case. And he violated my due process rights, or all 156 of us, our due process rights, by saying that our motion was denied. Our motion was authorized under the court rules. That's where I got the motion. That's where I got the idea for the motion. The DOJ attorney had filed scandalous material. And I listed a whole bunch of items that if the court acceded to these things, that they would be involved in this scandalous material.
the DOJ's arguments were barred by estoppel.
That's right. I told Judge Carmody that. And did she report it in her report afterwards? No. She just included what she wanted to include. So in other words, she knowingly and willingly suppressed evidence in order to give a reason to Judge Enslin